first, when the case is like this in court, it becomes sub judice to discuss it. But we're happy that we're part of the arguments that have been made, especially the fact that our lawyer was able to draw the attention of the court to the court ruling from the Court of Appeal. Ordinarily, one would say that the Court of Appeal is a court of superior jurisdiction. And one would also expect that having had a judgment from a court of superior jurisdiction on this matter, maybe we would have just said, okay, we can go home and sleep. But this is Nigeria. We hope and pray that the arguments that have been canvassed by our lawyer, especially as it has to do with that judgment, we pray that the judge will see reasons why this, should not go on. As a matter of fact, because ordinarily we would have expected as we came, the case will be dismissed. But like we say in law, we wait until the judgment comes out. But we're optimistic, we're upbeat that the proper thing will be done, because we're talking about the Constitution of Nigeria. We're talking about constitutionality. We're talking about the essence of why we're a country. We can't have courts giving different rulings, on the same matter here and there. I mean, it makes a whole mockery of the judiciary. But I'm confident that, the proper thing will be done, and if that is done, then we know where we'll be.
If you were in court, you would have seen that what the judge has done today is right. He had adjourned previously for judgment. A decision of a higher court came from Enugu. And in law, there is what we call the principle of stare decisis and res judicata. The simple interpretation is that lower courts are bound by judgments of superior courts. The counsel to the plaintiff, Kala SAN, tried to make heavy weather to say that they were not the same or similar. But the counsel to the governor and the deputy governor made copious references to several pages, and the relief sought in both cases to show the similarity of the matter before here and drew the attention of the court that what the Supreme Court has said, when judges or justices of lower courts have failed to go by the principle of stare decisis, particularly in judgments that are in rem. Judgment in rem covers the university facility, covers the world, whether you are a party to it or not. When pronouncements are made, you are bound by it. Today, Chief Michael Zuckerman, who is the lead counsel to the governor and the deputy governor, have just drawn the attention of the court to that. To us, we expect that the judge should follow what he has been urged to do. Because to do otherwise will amount to what the Supreme Court and the Court of Appeal have described cases before now. That amounts to judicial rascality, it amounts to judicial ignorance, and that judges of lower courts are forbidden from making speculative judgments. The law is clear under Section 180, Section 188, Section 189, on the grounds in which you can remove a governor. The case of Attorney General of the Federation and Abubakar was made reference to. So the latest precedent now that has to do with a governor being removed from office is this case of Senator Ogbochi against Umahi. So in law, we follow precedent. Don't say you don't have a precedent to rely on to do otherwise. You will be inviting the rule of law to anarchy, to unconstitutionality, and that might bring an end to the interest of justice. I do not think that an intelligent judge like Justice Tawota will make such mistake. Just like the Court of Appeal commended the court below in Abakaliki for not falling to the temptation of trying to legislate on clear provisions of the Constitution. I do not think this judge too will make such mistake. So that is the confidence we have.